E. Declaration of Existence of State of War. Section 23. 1. The Congress, by a vote of 2/3 of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. 2. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof. Note: the Philippines renounces war as an instrument of national policy. What the Congress can declare is the existence of a state of war or defensive war. Congress may delegate legislative powers to the President in times of war or in other national emergencies. F. Power to revoke/extend the suspension of the privilege of the writ of habeas corpus and declaration of martial law. Section 18. The President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. Within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus, the President shall submit a report in person or in writing to the Congress. The Congress, voting jointly, by a vote of at least a majority of all its members in regular or special session, may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress, if the invasion or rebellion shall persist and public safety requires it. The Congress, if not in session, shall, within 24 hours following such proclamation or suspension, convene in accordance with its rules without any need of a call. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with the invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days. Otherwise he shall be released. Note: this revocation and extension are the only instances under the Constitution where the Senate and the House of Representatives meet in joint session voting jointly and not separately. G. Power of impeachment. No impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. Initiation means filing coupled with referral to the Committee on Justice. The court cannot make a determination of what constitutes an impeachable offense. It is a purely political question. Impeachable officials. 1. President. 2. Vice President. 3. Members of the Supreme Court. 4. Members of the Constitutional Commissions. 5. Ombudsman, being officers removable only by impeachment bars any action that may directly or indirectly cause for their removal from office. Impeachable offenses. 1. Culpable violation of the Constitution. 2. Treason. 3. Bribery. 4. Graft and corruption. 5. Other high crimes. And 6. Betrayal of public trust. Note: no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. This applies even if the second impeachment complaint initiated is for a different ground. An impeached public officer whose civil, criminal, or administrative liability was not judicially established may be considered involuntarily retired from service and is entitled to retirement benefits. Section 2. The President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. All other public officers and employees may be removed from office as provided by law, but not by impeachment. Section 3. 1. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days, and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. 3. A vote of at least 1/3 of all the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee, or override its contrary resolution. The vote of each member shall be recorded. 4. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. 5. No impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. 6. The Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senators shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. 7. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines. But the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. 8. The Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. H. The Electoral Tribunals. Section 17. The Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to the election, returns, and qualifications of their respective members. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system represented therein. The senior justice in the electoral tribunal shall be its chairman. I. Commission on Appointment. Section 18. There shall be a commission on appointments consisting of the President of the Senate, as ex officio chairman, 12 senators and 12 members of the House of Representatives, elected by each House on the basis of proportional representation from the political parties and parties or organizations registered under the party list system represented therein. The chairman of the commission shall not vote, except in case of a tie. The commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The commission shall rule by a majority vote of all the members. Section 16. The President shall nominate and, with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until after disapproval by the Commission on Appointments or until the next adjournment of the Congress. Section 8. 1. A judicial and bar council is hereby created under the supervision of the Supreme Court, composed of the Chief Justice as ex officio chairman, the Secretary of Justice, and a representative of the Congress as ex officio members, a representative of the integrated bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. 2. The regular members of the council shall be appointed by the President for a term of 4 years, with the consent of the Commission on Appointments. Of the members first appointed, the representative of the integrated bar shall serve for 4 years, the professor of law for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. 3. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceedings. 4. The regular members of the council shall receive such emoluments as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. 5. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Note: unlike electoral tribunals, the Commission on Appointments can meet only while Congress is in session.